Please be the
Here.
court.
Here from the
I'm
appellant.
Robert Asbury of the Bristol Bar, and it's my pleasure this afternoon to represent the plaintiff and the appellant in this matter, Marina Kotova. Your Honors, I will state that I was not the counsel of record at the trial in this matter, and I
Counsel,
came
you
on.
want to reserve any time for rebuttal?
Just 3 minutes, Your Honor. Thank you.
3 minutes. Thank you.
What apparently the parties do agree to is that in November of 2019, a contract was entered into them about a piece of real estate that the defendant, the appellee, was going to buy from my client. Ultimately, payments were missed. The trial court found 33 payments were missed, and that constituted a breach of this contract on the behalf of the defendant. Now, since both parties contend and agree that a viable contract had existed between them, and the trial court agreed with that contention, I think we need to look at the actual contract to see if there are any provisions dealing with the way to handle damages in this case. And I would represent to the court that there are, and that's specifically in Exhibit 5, paragraph 11. It deals with default and says that the person that is not in default may sue for specific performance in this case. Now, why is specific performance important in this matter? It's important for the reason that the actual value of this real estate is greatly in excess of the contract price for the sale, so that whoever is awarded this real estate is going to come away with a significant gain. So whoever the court decides today gets this real estate, the other party is going to suffer a significant loss. I think we turn to settled Tennessee contract law that if we're going to look at who's going to suffer a loss, the loss has to be occasioned by the one committing the breach. And there was no question at the trial court that the defendant appellee was in breach for this large number of missed payments.
Let me ask you this. This case originated in sessions as a detainer action.
It did.
It then got appealed to circuit. Was there any subsequent complaint type pleading filed? There doesn't have to be when it's appealed that way, but sometimes people do just to clean it up.
I did not see one in the record, Your Honor. So
Okay.
It appears from the record that what happened at the trial is that Judge Lauterbach decided that instead of handling it as a detainer issue, which is also one of the remedies that's contained in the party's contract, he was going to look at it as a contract action. And I don't think there was any disagreement or argument against that by the party, simply because the detainer remedy is contained in the contract. So if you want to look at it whichever way, it allowed the court to take action.
So is it your position that your client basically had 3 remedies upon default? That would be specific performance, damages, and eviction?
That's correct.
Okay.
And there is also reference in this contract that the appellee, defendant, could make these payments over a period of 10 years. Now, the contract amount was $225 per month, and if that amount is correct, that would mean that the amount was paid off much sooner than the 10 years. The trial court made a specific finding of fact stating that he found that to be illogical, that was the intent of the parties, that on one hand, if you miss a payment, you're out within 30 days. On the other hand, I've got 10 years to pay you. But the practical effect here is that the trial court went into a liquid, and I hate to put words in the judge's mouth, but a liquidated damages analysis where he looks at all these amounts that were paid, and in the end, he awards the property to the person who breached the contract under the only provision within this contract that would allow him to do so, which was, he had 10 years to pay this off. At the same time, the judge is saying that this is not a logical argument to begin with. So someone is going to suffer a loss here, and it should not be my party who went without payment for it wasn't a continuous 33 months, it was 33 months spread out over a period of years. So I think that the contract...
Well, let's say this property had not increased in value, that it had in fact decreased in value during the time that all this was happening.
Then I think that you've got an argument that monetary damages could have dealt with the arguments by the parties about who had paid what. But since it didn't, and the fact that it's gone up greatly in value, and I think that the court can look at this provision in paragraph in Exhibit 7 that dealt with the requirement that the payments be made on time within 30 days or the detainer would ensue. I think the court can look at that and infer that time was of the essence in this contract, and that's where you've got the issue between the disparity of its actual worth and the contract amount, that the issue of time being of the essence was what resulted in those two different figures. So,
And then, of course, you have opposing counsel's argument that, I mean, basically, if we reverse, then it's a windfall the other direction, because your client didn't bargain for the benefit of increased value in the property in the event she should get to keep it. She bargained to sell it for $15,000.
and that's correct, Your Honor, but once again, since Mr. True, the appellee, was the one that drafted the contract, any discrepancies in the contract will be held against him. You know, should they have gone to an attorney to help them draft this and include these provisions? But they didn't, so here we are. And I do feel that there is sufficient language within the existing contract that allows us to craft a remedy within the four corners of the contract without having to go off into the weeds, so to speak, to craft a damage award that's not contemplated in the contract.
So do you agree that at the circuit court trial, you were okay? What did you want the trial court to do? Did you ask only for eviction, or did you go beyond that?
My understanding is that the argument was made that she wanted possession of the property immediately, and she wanted the cost and attorney fees that were set forth in the contract for having to pursue a remedy because the remedy wasn't forthcoming voluntarily.
So she didn't ask for it trial-specific performance?
Were those words specifically used or were they inferred? Not being there and reading it on the page, I can't give a 100% definitive answer to that question. I believe that it is inherent in the language of the contract as it stands that was the intent. If you don't pay within 30 days, you've got to get out. And if that was not the case, if there was this provision in place to give the defendant virtually a decade to pay it off, then this time is of the essence provision would not have been included. So that's really the essence of our case, is that it's an imperfectly drafted contract, but my client didn't draft it, and my client did abide by it, so she should not be punished when the other side breaches it. Thank you.
You have your time for rebuttal. We'll hear from the appellee.
My name is Regina Shepard, and I represent the
Excuse me,
appellee.
pull the microphone
Yes,
down
Honor.
some for us.
Is that
Thank you.
better?
Yes.
Thank you. My name is Regina Shepard, and I am the attorney for the appellee, Kevin True, and I am from the Carter County Bar. Your Honor, as far as the issues in this case before you today, it is correct that the parties did enter into a contract. It was a real estate purchase contract. The amount that the parties agreed upon was for $15,000. I think that the court needs to be reminded of just a little bit more of the history involving this case. The parties were married. They did purchase this real estate while they were married, and in their divorce proceeding, Mr. True was awarded the property. He did not have to pay any equity in the home to Ms. Kotova, and so he did have ownership of this property for several years after their divorce. Then in 2019, when the parties reached this agreement, he did execute a quitclaim deed back to her. However, at that particular time of the purchase, the parties did have a deed of trust. It was executed by both parties. However, Mr. True was the only party who actually signed the note, and that is discussed in the transcript at the trial level. why the parties did that. So even today, this mortgage is still in Mr. True's name, and he testified at the trial that he's still making the payments on that mortgage, and the testimony was that Ms. Kotova had only made payments on that mortgage while she lived there for a period of time between 2013 and 2019, but beyond that, Mr. True had made all of those payments. So we believe, Your Honor, that the four corners of this contract does provide for specific performance to be granted by the trial court, which that is what the trial court did. We believe that that opinion is correct and should be affirmed by this court. And the reason that we contend that, Your Honors, is because this action did commence in Sessions Court as a detainer. And in that action, Ms. Kotova was awarded $5,000 some odd plus her attorney fees and possession. So at that point, it's our contention that the $5,000 some odd that she received in that judgment was what she was owed under the contract. So in essence, she was wanting all of the money under the contract and possession and the attorney fees as well. And that is what was awarded to her at the General Sessions level. Mr. True then did appeal to Circuit Court. We did have a de novo trial there, and that judge rendered, in our opinion, the correct decision in that this contract was breached by Mr. True, and that specific performance should be administered in this so that he would finish paying the contract, and then she would she would execute a warranty deed to him to complete their contract. It is true
Counsel,
that...
let me ask you about the special or the seller's terms and conditions that
Yes.
contains the provision that says, at any default of 30 days, an eviction notice will be enforced, and Kevin True must comply with the after-written acknowledgement of this purchase agreement. I'm not sure what the after-written acknowledgement of this purchase agreement means, but I do know what, at any default of 30 days, an eviction notice will be enforced.
Yes.
So you agree that's a remedy she was entitled to under the contract?
We actually don't, Your Honor, and the reason we don't is because at the trial, Mr. True testified that Exhibit 7 was actually prepared by Ms. Kotova. He testified that Exhibits 5 and 6, he had prepared those, but she had prepared this one. So the law does provide that any ambiguous provision in a contract is going to be construed against the party that constructed that part of the contract, and our contention is that this part of this contract is ambiguous. It's not in line with a real estate purchase agreement. Basically, in essence, like I stated before, what she is wanting done is basically she wants to keep this property, and she wanted him to pay her this property and pay for her attorney fees, but she didn't want him to have the property. And as far as the increase in value is concerned, it is clear to us that she bargained in 2019 to sell this property for $15,000 to Mr. True. She's bound by that agreement. She executed, although it was not prepared by an attorney. They did discuss it, they met, they talked it over, they both signed it. So we believe that the trial court should be affirmed in that Mr. True should be ordered to pay her the money. She should be ordered to execute the deed to him, mainly because of the contract as well as the issue of that deed of trust that is still out there, that mortgage with Wells Fargo.
Why, I guess as a broader question, why does he get the benefit of the contract when he's the one who breached it?
Yes, Your Honor. So it's our belief that the court actually granted specific performance to her, not to him. He is the party that was found to be in breach. He has to finish paying her the amount that is due to her. So she was the prevailing party. She received her attorney fees in that action. He didn't receive specific performance. If in essence, let's just say this, if he had paid her and she had not appealed and then she didn't sign the warranty deed, then he would be asking the court for specific performance. He didn't ask the court for specific performance. He just appealed the detainer action part because, in essence, at that level, she was receiving the property and the money that he was to pay her for the property. So she would have received a windfall at that juncture. And of course, we believe that the windfall issue is, I've already talked about that, but because he has been the one making most of these payments to Wells Fargo, except for that window of time that I mentioned earlier, he's the one that is paying down this mortgage more than Ms. Kotova did. And as far as the attorney fees, we did bring up the issue that because Ms. Kotova did file the motion to alter or amend judgment and was denied that relief, we would ask for his attorney fees to be awarded to him. And if this court does affirm the trial court decision, we would ask that his attorney fees for this proceeding be awarded to him as well. Thank you.
Thank you. We'll hear from the appellant rebuttal.
Just briefly. We believe that any rendition of facts that occurred before the
Counsel, if
party,
you would pull the microphone up. Thank you.
we believe that any rendition of alleged facts occurring before the party's 2019 contract are irrelevant. But I will say that in the months leading up to that 2019 contract, the information is contained in Mr. True's brief that Ms. Kotova had to pay him $5,000 to keep the property out of foreclosure then. Is reimbursement of that amount dealt with in this contract? Not at all. The second thing, the allegation or claim that Exhibit 7 styled as seller's terms and conditions of purchase agreement, that fact of who drafted that part of the contract was disputed. The statement that the appellee said that the appellant drafted it, that was his statement at trial, but there was no finding at the trial court where Judge Lauterbach found that he agreed with that statement. So we dispute the contention that this subsequent provision in Exhibit 7 should be given the same degree of scrutiny that the provisions in Exhibit 5 are given. So without the benefit of a liquidated damages clause, it is true that someone is going to have more of a windfall than would have been the case if this contract language was included, but it's not, and we're left with the four corners of the contract, and we believe that the case should have been decided firmly within what was available to the court at the time. Thank you.
Of course, thanks to both counsel. We appreciate your arguments today and your briefs in this matter. If you would, please adjourn court till tomorrow morning at 9:30 a.m.
Thank you. All rise. This Honorable Court of Tennessee